whatever. But in a case like the one I want to talk about today, the hot soup burn case, comparative fault is everything. I mean, that's the hill that the defense was going to live and die on ultimately. So let's kind of deep dive into that case, and it'll give us a few little facts and tidbits that we can pause and extrapolate on. So this is a case in Gainesville, Florida, in Alachua County, where the University of Florida is. Our client is born and raised Gainesville. She was in her mid 30s, black female, professional assistant in the UF health system in terms of an administrator. She was on her lunch break in September 2020, and she went to a local shopping center where she knew there to be a Vietnamese restaurant. She'd been there on a handful of occasions before, always ordered the same dish, which is a soup dish with like a chicken broth base and a few different condiments that you toss in. On this particular occasion, it was a little busier than usual, and they were just delayed in giving her order, but she went in person to place it, waited a few minutes, and when it was finally ready, they handed it to her in a single bag. And that was different than how it had been in the past, at least by her recollection. The defendant disputed that in discovery. But basically, they packaged it as following. There was a square styrofoam box, those flimsy boxes, inside of which was lettuce, vegetables, chicken, whatever you're going to put in the broth. And then stacked on top of that was a heavier cylinder, a plastic Tupperware cylinder of the hot broth stacked right on top. And then they put all that in a thin white plastic bag to go and tied it at the top. So they hand this to her, and right out of the gate, they don't warn her verbally. There's no comment whatsoever about the soup is super hot, it can burn you, whatever. And, for a lot of people out there, you might be saying to yourself, like some of the prospective jurors in our focus group did, everybody knows soup is hot. Why does there need to be a warning? I think if you just stop and you drill deeper on that, John, I don't know how you feel about it, because we did bring failure to warn claims, both in like a negligent sense and a products liability sense. We need warnings on products, or we need warnings about products, even when the risk is known, because we cannot defer to every consumer out there knowing every conceivable way in which a product can harm them. So in this particular case, I caution people to think back, the hot soup case with the Leibowitz plaintiff 30 years ago. Now you've got hot or caution, contents hot on virtually every hot liquid you buy. It wasn't on this one. We still have it just the same way I tell people all the time. I mean, why do we need signs on the side of a highway that say, deer could be crossing? I mean, everybody knows the woods are around, a deer could come. But we want to do more to protect people in this country. We want to do more to protect people in the state of Florida specifically. And even though the danger, the risk is technically known, we want to do the right thing and remind people from time to time at that transactional level, hey, I'm about to hand you something that's dangerous. Be mindful, because we've all got other stuff going on in our lives. And I think people are entitled to at least that minimum level of decency and courtesy. And the law reflects that. How do you feel about warning?
Well, I think that, you said that the hot soup case, and it's actually the hot coffee case was the one we're talking about, the McDonald's hot coffee where the woman spilled it into her lap, where she actually was doing more, all right? She's sitting in the passenger seat. She's opening it herself. She's trying to put it in, and she spills it. Now, the issue in that case was that they had, 700 plus burns beforehand. They knew about it. They were cooking it to a temperature so hot that people in the store, because they had free refills, wouldn't allow them to drink it fast enough while they were sitting there, so they wouldn't get a refill and they could save money, right? And that's kind of what these things are driven by. A lot of times it's a monetary decision for these companies to do things in a certain way. In this particular case, while yes, soup is hot, you expect food to be hot or warm when you buy it. The problem is what you don't expect it to be is scalding, right? And we know this because Jordan, kind of what he did is we actually, as the plaintiff's lawyers, we hired investigators. And a lot of times we deal with surveillance on the other side. You have a person that's claimed they're injured. The defendants fall around. Sometimes they come out of cover of darkness. They sit outside their house with a little screen and outside the window, and they videotape them and fall around and say, aha, you're not hurt. Look at you. Here you are working. Here you are smiling. And, they try to use that to our advantage. Now there's ways to deal with that at trial. So we did kind of the same thing. Before we even filed the lawsuit, we sent in private investigators to order the same thing. And what they realized and what they got was that they weren't provided any warnings of the contents. And then we tested the temperature. And, I think we tested temperatures anywhere from 173 degrees to 100. And then the second round of surveillance was 189 degrees, right? the time it takes and the level of burn for giving to someone at 189 degrees is quick. And so when you're talking about warning someone, like, look, yes, I know soup is hot, but is it this hot? Is it
Right.
don't even touch this thing? And we know that afterwards, after this lawsuit was filed, they started telling customers, this is hot like lava.
That's what I was going to say. So one of the investigators we ended up sending in, we sent 3 rounds to disclose to, kept the other one as work product just because, it got redundant at some point. But one of the investigators went in there after the lawsuit was filed, after these claims were being heavily prosecuted and litigated. And then the defendant started changing its conduct, and it would change the packaging. So instead of a flimsy white paper bag, it was a brown paper bag. Instead of no written warnings, there was now a huge orange sticker with a fire symbol on it that said hot. And then you want to talk about verbal warnings, they would not really even hand the bag over until they told the investigator it was hot like lava. And if it's in your car, it can burn you. If you touch it soon, it'll burn you like lava. So clearly, we talk about greater good and altruism, and, you want to help one plaintiff at a time, but if you can set some ripples through the lake and change something larger for the greater good of society, that's great. And obviously we know in this particular locale of Florida, in this restaurant, we've made that change. I thought what was different on the warnings, really interesting, was the defendant in the 30B6 depo said, we warn everybody. I tell all my employees to warn everybody, of course. Even though soup is hot, we still warn people. Of course we do that. When, of course, on 6 different occasions over 2 years with 2 different investigators, they never had done that. Until we disclosed that information, they realized what we had, and then now they changed their behavior. But John, I don't know how you felt. So the defense, they didn't even hire a medical expert. We're going to talk about the damages later. But on the warning side, they hired someone with like 50 years working in restaurants. He had owned some restaurants. His son had owned some restaurants. He managed them. He trained people. He had never served, Vietnamese soup dishes before. But They bring this guy in, and this was his first time ever testifying as an expert. I think that showed in his deposition because he took some kind of unbelievable, incredible positions in his discovery deposition, even on the topic of warnings. So I asked him, look, the defendant says that they warn people. That's a reasonable thing to do, right? So if my client says on this occasion they didn't warn her, that's a problem. And he went so far as to say, John, you'll recall, I think he said, no, a restaurant never needs to warn anybody about anything. Everybody knows soup is hot, and therefore it would be unreasonable to warn. It's so above and beyond. You don't even need to do that.
Yeah, that's what he said. He said it's not reasonable to warn someone. And then he also went so far to say there is no maximum temperature at which you can serve someone a hot liquid. And I was like, so then you can give someone, by his logic, boiling hot soup. I can take it right from the boiling stove, put it in a dish, serve it to a customer, and that's safe. And it's just, that kind of testimony.
He finally started to concede on that one.
Well, because
that hypothetical.
What he was trying to say is that there's minimum food temperatures of which things have to be heated when. So the way they processed this was they cooked large vats of this broth first, right? Then they stored it in a refrigerator overnight, and the next day during rush they would heat it up, heat the contents up, and put it in a to-go container. That's what they did. The health regulations require, if you do that, and this is for the protection against foodborne illnesses, is that they have to heat it to 165 degrees. That has to maintain that temperature for 15 seconds, I think. And then it can't fall below 135, right? That's like the danger zone, they call it, where you could have, I guess, bacteria development and things like that. That's it. There actually is no food standard in Florida, and I don't even think nationally, as to the appropriate temperature that you can serve something. But the lack of a standard doesn't mean giving someone that hot with no warning in a container that really can't withstand that heat is reasonable, right? Because
that's the standard. That's the legal standard,
right.
Reasonable.
And to Jordan's point, I think that a lot of the things that like look, plaintiffs' lawyers get a bad rep. But the reason why products are safe, the reason why bad drugs are off the market, the reason why, there's recalls is because someone was harmed. They had the courage to fight against these large corporations. And this one wasn't a large corporation, but and effectuate change to protect the next person. And I guarantee you this will not happen again. Well, I don't want to say.
Yeah, I mean, we know that now with that third investigator who went and with the lava comments.
We've made
warnings. warnings are super important. And I agree with John. When we were prepping this case for trial, it was John who broke it down in a way that I think, had we tried this case, would have resonated with jurors, which is like, look, we all know soup is hot, but is it reasonable to warn people? It's reasonable to do that. Well, if it's reasonable to do that, then you should do it. And if you don't, then that's negligence, right? It's not about whether it would have prevented this definitively or not. It's just what's more likely. And I think a warning here definitely would have helped. Now, I want to switch gears. We talked about the temperature of the soup, and you're right. There was the hot coffee case all those years back with McDonald's. If memory serves me, in that McDonald's case, the Bonomatic or whatever machine they were using to heat the coffee was bringing it up to about 180, 190 degrees Fahrenheit. And they had, if I recall correctly, all kinds of experts to explain you need that, whether it's for taste, aroma, so that it's not cold when somebody takes it to go and goes home, whatever it was. They had all these experts explaining the reasons. It's interesting here, though, when we set the defendant for depo. Now, mind you, the soup spills. Nobody took the temperature of the soup before it was given to my client, meaning there was no internal temperature logs in the restaurant. As they bring it back up to heat, kill those foodborne illnesses. Nobody's sitting back there with a thermometer, taking the temperature, writing it down, and then giving it to our client. But in the deposition, that's what the defendant said that they did. She said, oh, no, here, she even held up, here's this Taylor digital kitchen thermometer, and everyone in the kitchen knows you have to check the temperature before you serve it. I thought it was a ridiculous position. I was surprised that they even made it. I think had we gone to trial, that would have really blown up badly for them. But I got to use that against them, because then I said, okay, well, if you're checking the temperatures, that must mean you have certain thresholds you're checking them for. Meaning if you check the temperature and it's past X degrees, you're not going to serve it because it's dangerous, or if it's lower than Y degrees, you're not going to serve it for foodborne illnesses. So they kind of backed themselves into a corner where they had to they had to be the ones to create what was a reasonably safe temperature, because it didn't exist in the regs. So in doing that, I just kept pressing. Well, what about 150 degrees Fahrenheit? Oh yeah, that's fine. In fact, it's got to be 160 and so forth. It got to the point where the designee for the company basically said, look, anywhere between 155, 165 is where we've got to heat this thing at least. I said, well, would you ever serve it at 170 Fahrenheit or hotter? No, we wouldn't do that. At that point, it's starting to get too hot. I would be concerned about burning a customer. Now, mind you, I'm sitting there. I know my investigator has already been there, and the soup's in excess of 170 degrees Fahrenheit every single time it's ordered. I hadn't yet had the second investigator come back at 180 plus, but I assumed that it might happen on occasion. So I boxed her in and I said, would you ever knowingly serve this soup? I mean, you're back there checking temperatures. Would you ever knowingly serve it at 180 plus? Yes or no? No, we have never done that, would never do that, that kind of thing. Why not? Because it would, at that point, it would clearly burn a customer. Well, now she's given me the evidence. This corporation, it's a mom and pop corp, but it's a corporation, has given me binding 30B6 testimony that they have now created internally an expectation where if their soup dish is hotter than these thresholds, it's too dangerous because it could burn a customer. Now I go send out another investigator. Lo and behold, despite what she's telling us in a deposition, in real life, when they're handing these packages to customers, they go out to the parking lot and check the temperature with a thermometer. It's 180 plus.
Yeah,
almost 190 plus.
189 degrees. And the problem is she used the word that I tell my clients and when I prepare them for deposition to not use, which is never. Right? She said, we never do this. And then here we are, we have 3 separate occasions on 3 different days, and you're doing it every time. Right? I mean, that you're a liar. That is, you lie. You say, we never do this. You claim you test the temperature, which is not true, but that's what she said. So that means you are knowingly serving in excess of these temperatures and then claiming you don't do it. And so,
right. And that was a big point we leveraged. Remember earlier in the case, we sought leave, to amend for punitive damages in Florida. You can't just outright plead punitives. You've got to bring your claims first, and then through some discovery, get some additional evidence that meets the statutory threshold, which is a reasonable showing of a reasonable basis to recover, whether for intentional misconduct or gross negligence. So we had these investigators, 6 different occasions over 2 years, 100% of the time, it's in excess of temperatures that the defendant has admitted in a 30B6 are dangerous. So we used that to amend for punitive damages, but it was denied. And that took the wind out of my sails a little bit for my client, because I was pretty confident based on that limited threshold that we needed to get over, we could do that. And had we amended the pleadings, I think it would have given us a better chance at an earlier settlement, but it was denied. So now we're back to square one. We've got this good evidence. Maybe it falls nicely on a juror's ears, but what can we do with it before trial to leverage. And so it became this big dispute, which ultimately memorialized itself in competing motions in limine. The defense took the position, we violated rules of discovery because we were basically conducting unnoticed side inspections. That's how they framed it. And then B, even if it was lawful for us to do that under the discovery rules, it's all subsequent to the accident here. So how is that possibly relevant? And these allowed us to actually delve deep into some parts of our evidence code that we don't always get to use, right? I think everyone remembers from law school, subsequent remedial measures and all that. So it was interesting on just the evidentiary side, putting the discovery thing away, because it was kind of nonsensical. Those discovery rules exist to protect rights to privacy. There's no right to privacy in a lobby of a restaurant open to the public. So that didn't really come to pass. Let's talk about the evidence. We basically said, look, a couple of things here. It's not even a remedial measure because nothing's changed, right? They tell us they don't do this, and over 2 years, 6 different occasions, every single time they're doing it. What's remedial about that? Nothing. So this is actually, we changed it. We went one section back in the evidence code. I think it's 90.406, not 90.407. It said, this is evidence of a routine practice of an organization. And in Florida, can't speak in every jurisdiction, but in Florida, there's a statute in our evidence code that says, if it's a person you're talking about, you can't use it, right? Pattern of conduct, bad behavior, 404 type stuff. But if it's a company and you have evidence of a routine practice, like a habit, even if it's uncorroborated, you can use it in a trial. And so that's the argument we presented. We never got a definitive ruling because the case settled on the eve of trial, but that was kind of the battle we were having. And also, for the Florida practitioners out there, and I'm happy to share this work product, but there's some good cases out there that explain even subsequent incidents can be admissible as long as they're used for a proper purpose. A primary case I think it's out of the 4th DCA, even though the plaintiff there was at Disney World in Orlando, you would think a 5th DCA case. That was where someone got hurt on the bumper cars at Disney World or some similar ride, hurt their back. And then it turns out after they got hurt, a few more people got hurt on the same ride. And there was a debate whether or not the rules of evidence allow that evidence to come in. Trial court in that case said no, got reversed on appeal. So we had the benefit of binding precedent because there was nothing to the contrary. So there were some interesting points, but all of that to say this: you're sitting with a case where your client is horrifically burned, disfigurement, pain, suffering, all of these things, mental anguish. The damages are legitimate, but liability is tough because there's no temperature log to prove what the temperature was. And, our client, like probably anybody else reasonable, at least any other reasonable person under the circumstances, the soup is spilled. What are you doing? How are you going to manage to figure out how hot the soup was? You're trying to address these burns of your flesh, right? So the defense used that against us, though, and I thought, to give them credit, they did an effective job during the discovery and motion practice stage by saying, this is her fault. First of all, she took the soup off our property. Once that happens, why should she be responsible? She was in her car when it happened, and she discarded the soup container. So let's kind of drill deep on that, John. Let's start maybe with the soup container. One of our claims in the case was that the packaging, the literal plastic broth container, was not suitable for temperatures of broth like this. And it was interesting because we didn't have the container. Our client threw it away. So there was these competing notions of, well, here's some exemplars and what we think that shows versus, hey, from the defense, hey, the plaintiff spoliated the critical evidence here. We're prejudiced.
Yeah, I mean, it's difficult because, on the one hand, we kind of go after the defense for destroying evidence, and I think in this case, I don't know, Florida's kind of, it's not really clear sometimes on some of their rulings and decisions, because it seems to me like there has to be a duty and obligation. Sometimes you got to send a spoliation letter to the defense to trigger that duty. But when it's the plaintiff and they're the one harmed and they have the device that harmed them, is their duty kind of automatic? And it's not really clear for me, because and people may not be thinking like, oh, I need to sue someone immediately when something happens, right? It spilled on me. I cleaned my car out. I threw the shit away, So I think we had to deal with that. But the problem is that we have her testimony. And her testimony was basically, when I moved, what she tried to do was take it from the floorboard because it was sloshing around and wanted to put it in her cup holder. And as she was taking it in the cup holder, she said it kind of malformed and the top popped off. But she said, and this is kind of important because she said there were no holes poked in the lid. And if anybody who's gotten Vietnamese pho soup and they order it, look at the top of the lid. There's holes poked in there. They do that so that temperature, that steam can escape, lower the temperature. And so it didn't have that. So it kind of had that steam inside. It pops off and then spills all over her. But then we don't have it, right? So it's just her word saying that was the case. And so, I think that created a challenge in the sense of, you're the one that spilled it on yourself. We did the focus group, and a lot of people were like, we don't believe her. We think she was trying to eat it, which I don't think they've ever eaten pho soup because you don't eat the broth. You have to mix it with the ingredients that's in the other container. But, so that was something that, back to the comparative negligence argument is that we had a case where, our concern at trial was overcoming her fault, right? Someone gave it to you, you put it on the floor, you were more concerned with it spilling, and then you took it out and spilled it on yourself. Now, she says it's because the device or the thing failed, right? With something we don't actually have, and it's the standard.
And remember, by the way, the defendant at least gave us the evidence we needed to argue it beyond just our client's word, which is, remember, in 30B6, we talked about those holes in the top, and it was the defendant who said, look, we buy these plastic containers, we are under the impression they're suitable for soup, but we know that we have to poke 2 or 3 holes in the top to let that steam out. Why? And she said, because otherwise the lids pop off. So we had something to pull, yarn to pull, but yeah, when you don't have the product and you're blaming the defendant, and the defendant is going to be able to walk into trial and say, they want us to believe the plastic container was defective, and then they threw it out. That's not fair to us. And there's a legitimate argument there. And by the way, on the legal side of it, forgetting trial, I'm talking pre-trial, the defendant moved for spoliation sanctions in the form of an adverse inference. It would have been a jury instruction, which is that, you don't need to, jury, but you can decide that the evidence actually would have been favorable to the defendant, but nevertheless, the plaintiff discarded whatever. And fortunately, we had a hearing on that. The judge decided this is not something best decided before trial. It's better decided in trial when both sides have rested, so we know definitively what the record is. So that was going to be something we were going to have to readdress. But yeah, John, your point is valid, which is that it's a legitimate concern, and it also bears on the comparative fault. And it's just hard in a products liability case without the product to really press that too aggressively without looking a bit unreasonable yourself when your client discarded it. No matter how reasonable it would be for anyone in that circumstance, having just been burned, to throw out the container, right? Lawsuits aren't on your mind. But let's talk about comparative fault even more, because there's so much to it. This was their defense, and there was a lot for them to work with. One of the things was, why did you move the soup at all? Right? You get a package, it's already tied, you put it on the passenger floorboard. Why move it at all? And because you chose to do that, how is that our fault? And so that's why we had to talk about negligence in terms of packaging, not just the plastic container itself, but how they're stacked, right? The idea that you don't put it in 2 separate bags, you don't put it in a cardboard box or divide things with cardboard. You're taking the heavier, denser object, you're putting it on top of a flimsier object, right? What's going to happen there? Especially in a moving vehicle, you're serving this to go, people drive. It's going to slide around and create a risk of spilling. So that was how we kind of at least anticipated getting around that. But I can assure you out there, that was a big drum that the defense was beating, and they had more than just common sense to work with, John. Remember, some of the medical records here, I want to be respectful of our clients, HIPAA protected rights. So we won't get into the exact specifics, but what we can talk about are, generally speaking, there were some entries by some of her treating physicians, her initial PCP she went to, the burn clinic at the local university she went to, and dermatology, right? These types of providers. There were some entries in there where the history of present illness was not always consistent. Right. And the defense was doing a good job kind of making that seem bigger than it was. Maybe you can shed some light on that.
Yeah, it had one where, she spilled it on herself eating in the restaurant. The other one was like she was eating it in her car and spilled it on her lap. And, these are things that the defense jumps on, right? They take snippets from a medical record of, oh, well, they didn't say this, or they mentioned this, or they had this, or here's what it really says. And they can be difficult to overcome. We had a case in a premises liability case where in the hospital, now he says he fell because it was wet and they had just painted, but it was wet from, I don't know what it was, but we turned down the case ultimately because in the hospital record, it says client was in a rush and he stepped down and missed some steps and fell. I was like, what am I going to say? That's completely wrong. Some independent hospital from a story that you told them. And so that presented a challenge on the damage side. And that's kind of like why this case took so, I don't want to say it took long, but, they offered 50 grand. And then we just kept beating our drum of like, we're going to go to trial. Great, awesome, good job. And we just kept working, kept moving it. And it went from 50 grand. Then I think it was like, then they went to 125. And we served a proposal for settlement for $250,000. Right. And in Florida, for those of you that don't know what a proposal for settlement is, you can send a proposal, either plaintiff or defense. If a plaintiff serves one, they have 30 days to accept it. If they do not accept it and you go to trial and get 25% more than you offered, they have to pay all of your attorney's fees from the date of the offer. And the same for the defense. If they serve one and then we go to trial and we get 25% less than what they offered, then we have to pay all their attorney's fees. Now, we'll talk about that here in a moment about some of the things you can do to counteract that. But we were willing to settle pretty reasonably for 250 grand for someone that's scarred for the rest of her life. They said no. And then, then it was 125, then it was 250, and then it was 350. And just recently, I mean, they had a discovery issue. We stayed that. We took a writ to the was a first DCA on a constitutional right to privacy issue. That we didn't have a claim for medical bills or lost wages or anything, but yet they wanted to have her her employment history. They wanted her transcripts from college, and we're like, none of this is relevant to this case, and we have a constitutional right to privacy, and we took it up, and it was pending, and they ordered them to file a response. And so we were kind of hammering them from all fronts, going to trial. Judge denies the continuance. Then they move to stay. Judge denies that. And then I think they just, under immense pressure, finally offer the policy limits. And think about that. A case that we were willing to settle for 250 grand, we do a proposal for settlement, and then they probably spend, including attorney's fees and experts and all this, probably spend another $1 million, including this rather settlement. And that's why sometimes having that confidence, that ability to just go try the case, right? They're not willing to put any money.
They need to know that you're going to go try the case, right? It's not just an internal thing for yourself as the lawyer out there. I'll try this if I have to. I mean, you have to have that kind of confidence. It's that the other side has to know and believe in their heart you're going to go and you're going to try the hell out of it. And there's a really good chance that they'll lose, no matter how good they feel about their case. John and I joke, in some ways, I want people to look at us like cowboys. We're competent, we're confident, and we're a bit reckless, not outside the rules I'm talking about. Reckless in the sense of our risk appetite is a lot higher than other people. So John's point about the proposals for settlement is an interesting one here, because we served that, our PFS at 250,000 as soon as we could statutorily, which means really early in the case. I think once we served that, perhaps on the other side, what they thought was, look, these guys are looking to settle it. There's a lot of, pimples on this thing, so to speak. There's comparative fault. There's a missing product. There's going to be spoliation. You name it. I think from the beginning, they just thought eventually we'll cave. But we had to flip that on them and make them believe otherwise. And we did. That was legitimate. We were ready to try this case. And I think that's what got to the settlement. But before I kind of put the medical records thing to rest, because I think it's an interesting point in any case, not just this case. The defense, you have to anticipate, the defense is going to look through, they're going to leave no stone unturned, right? They got the big, deep pockets of an insurance company behind them. If there's a medical record or something they can do with surveillance or social media, whatever it is to undercut your client's case, they're going to do it. And here they had it served up on a platter with a multitude of different medical records, all within a close proximity to one another, each one attributing certain statements to our client about how it happened, and they're all inconsistent. Now, fortunately, some of them were so ridiculously inconsistent with the truth that it started to undermine the credibility of all the records, because they're all from technically the same university health system. So, for example, one of the records says she's eating soup in the restaurant, as John mentioned.
Right.
Undisputed, she wasn't in the restaurant. So we know that's false. Well, if one provider is attributing that statement to our client and it's patently false, then maybe some of the others are. And then you go to another record in the same visit. One of the nurses said soup was in her lap when spilled. But in the other page of the note, another nurse said she was moving it from the floorboard to the center console. So that was more consistent with what our client had said. Now, when you give the defense all these different versions, it's easier for them to just say, look, throw them all out. She was just probably eating it, whatever. And then we had to just we had to rebut that by saying, look at the medical records. They were also attributing that she said she lives with her grandparents. Unfortunately, her grandparents died, during the pandemic. So that's clearly inaccurate, right? Like I don't want to make light of it, but I mean, you have to show other things that are clearly not true in the records to kind of flesh out. And when we depose these providers, John, deposed the primary care provider, you have to give them something to work with that they can give you something back. So in this instance, when John deposed the primary care provider, the defense was taking the lead. Look at this part of the note. Look at this part. And this is what she told you, isn't it? This is what, the plaintiff told you. And this is what you wrote down because it's true. Yes. Right. They're going to live and die with their note. How many patients do they see a day? How long ago was this? They don't truly remember. So they're going to look back at their note and say, whatever I wrote there, that's it. Well, so John had that challenge to deal with. Maybe you could talk about that.
Well, I mean, we did this in the last case was that when the defense is using a medical record, one of the things, and it's clearly wrong and it's clearly inaccurate, people don't just want to accept that, right? Like, oh, why would this independent doctor? But we have real experience. They're human beings. They make mistakes. We had the trial where we talked about where our client, had bad things in the records, and we're like, this is not right. It's clearly wrong, and here's why. They also said she had a baby 4 hours after
after named her baby. Yeah.
Right. Which clearly is inaccurate. And then you use that against the defense experts who are only cherry picking that information, and they'll be like, okay, well, when are they having a baby? And so this is the same thing. I was confronting her, and I was like, are you sure? Well, I don't have an independent recollection of this, but this is what she would have told me. I was like, okay, well, you also have here, you check down in your notes, like all of these things, and one of the things you checked was that she lived with her grandparents. Well, her grandparents were dead at the time they saw you. How is that possible? And she has no answer for that. I was like, if your note is 100% accurate, how are you indicating that she lives with her grandparents that are no longer living?
Right. Is it that she told you that, or is it when you saw 20 people that day,
right,
and you went back at the end of your shift, you remembered, oh, this plaintiff, that patient, rather, she said something about soup. I think this is what she said.
Well, right. And her chart was open for like 3 hours. And it was like a 15-minute visit. And that was the other thing is like, well, when did you write this? Well, was it at the beginning? Was it at the end? You didn't close your note for 3 hours. So, and how many people were you seeing at that time? And so like, I think the defense counsel was like, you're attacking this woman. You suggesting she's he's not even her lawyer, and I was like, no, I'm pointing out the fact that she can't say that everything in her record is accurate. And she finally kind of conceded that, yes, there are inaccuracies in the record. And that's all I need, right? Let me take the rest
that's maybe a learning point for other people out there who, whether it's an expert witness or a medical provider, just a treater. And obviously you want to be respectful to these people. You want to be respectful to anyone. I don't care who it is, but you have a duty to your client to zealously advocate for them. And in the specific context of the deposition of a provider whose notes are unfavorable and seemingly incorrect, you've got to press. You can't be afraid to ratchet up, how direct and aggressive at times you are with the witness to get to the truth, because that's what your client's entitled to. And John did a really good job with that. And we did the same thing with some of the other providers. So I mentioned earlier, they didn't have a damages expert because what are they going to say, right? The burns speak for themselves. It's clear she got burned and there's really no legitimate basis to suggest they came from anywhere else. We actually used the attending burn surgeon from her treating burn clinic that she went to. We used him as an expert. We reached out. He remembered the case. We gave him the records, and he was willing to be an expert to explain these are 100% consistent with a scald injury from a hot liquid. You can see with the way the scarring is dripping down. It's consistent with everything that she said. There's no other explanation for it. These are second degree, deep partial thickness. You start explaining all that, and they're permanent. Our client was a Black woman, and there were even additional concerns above and beyond what most people think about with the scar was elevated or pigmentation issues. And these were all things that we had to be appreciative of as we were building to prepare our case for trial so that jurors fully and deeply understood the impact of this. But again, they didn't fight on damages. They weren't really going to. They were going to fight on the amount we asked for, but not that she was scarred. So the real question turned back to comparative fault with our client was, okay, is this legitimate? Like, was this a woman who was actually just eating on her lunch break, had an accident that is 100% her fault, and looking for some money? I mean, that's just what the defense goes to. We can't fault them for being skeptical, but that's not what happened here. And we had some other evidence to support that. The Google Maps basically showed that from where her office was located to the restaurant was like a 6-minute drive, super quick. So at the red light where she said it happened, she was only a few minutes away from her office. What does that show for us? What were we going to say at trial? We're going to say, look, this is not a 20-minute drive. First of all, there's no evidence she was rushed. There's no evidence she had to be back to clock in, that kind of thing. And she's so close to her office. The reasonable thing to assume here, she was going to wait until she got back. So she wasn't eating. The other thing is there's no scars on her hands. There's no scars on her lips or tongue or cheek or face. So if the soup is so hot that the moment it comes into contact with your skin, it's creating second-degree burns, where are the rest of the burns, right? The only burns were the ones that went through her clothing, on portions of her lap and stomach area, that are consistent with someone bringing something from the passenger floor towards their body because they got to go near the center console. Then the lid comes off, the plastic container loses its form, and it spills everywhere. I mean, that's what it was consistent with. So we had that to work with. But John, you mentioned something, and I don't want to skip over it because this is something that comes up, unfortunately, in my opinion, in a ton of different cases. It doesn't have to be hot spill. It can be a random car accident with orthopedic injuries, which is the defense wants to uncover seemingly every aspect of your client's life. I think many defendants, insurers, the counsel that they retain, they look through the lens of, if you have filed a personal injury lawsuit, you're putting your whole life on blast. I don't care what it is, when it was, what the source of it is. I'm entitled to get it because you're asking for pain and suffering. And they always say the same thing. Well, I got to know, did you have other issues in your life, psychologically, whatever, that made your life miserable to begin with? So how could this have made it worse? These kinds of things. We deal with that all the time in a myriad of ways. But in this particular case, you go through basically all of discovery. You're getting near the disco cutoff. And I think that's when the defendant realized we were really going to try this thing. So now they're scrambling because their client is a wonderful mother of two beautiful kids. She's actively involved in their lives. She's engaged to be married. She's born and raised, salt of the earth, super credible. So they had to find something. So they were on a mission. They proposed to serve subpoenas to her college. They wanted her transcripts, her admission paperwork, her test scores. I mean, trying to see what kind of student she was. Why? I have no idea. They served subpoenas to her private health insurer, which in a general sense might not be problematic, but they wanted everything, including any payouts of benefits from other cases, her application for benefits, personal injury protection logs. I mean, there was no evidence she had ever had a prior burn at all. They had all her medical records, no evidence. So that was kind of aggressive. And then they wanted her employee records. This was the one that really jumped out to me, and the client was really upset about. We fought for her with her constitutional right to privacy under the Florida Constitution, which is to say, I'm not making a wage loss claim. I'm also not making a claim that I can't work in the future. So if I'm not making those claims for economic damages, why are you asking for my entire employee file? Excuse me, time off, application, any reprimand, whatever. And the defense really didn't have a good argument for a lot of these things, the college and the employment. Basically, what they were saying is, we're fishing to try and find some basis to say that she's either not a good person or she's lying. For example, our client's testimony was that after she got burned, she finished to drive back to her work parking lot, realized this was more serious than even she, I think, initially thought, called her supervisor and said, I got to go home, take the rest of the day off, which she did. 3 other witnesses corroborated that. Her fiance, when he got home, her mom, her friends who called, whatever. The defense said, no, I need to get her employee file because maybe the person she called maybe made a note. And if he didn't make a note, what? Does that mean she didn't make the call? Those kinds of things. So we put up a big fight, not just into the untimeliness that they're waiting to the 11th hour to do this, but to say that just because you're a plaintiff in a personal injury case does not mean that there is no limit and that your right to privacy just dissipates. And so we presented that argument. Unfortunately, the trial court did not rule in our way. The trial court actually entered an order compelling our client to disclose, or these non-parties to provide all of the information. There was no limits. And that was one of the reasons we took an immediate appeal. We filed a petition for writ of certiorari in the First District Court of Appeal to say, look, there's a constitutional right to privacy at play here. Here's all the case law. Here's all the reasons why it should apply. And the trial court didn't even put in that kind of intermediate safeguard of saying, well, let me look at this stuff in camera and even see if it's worth disclosing if the defendant needs it. And John, I know you have dealt with this in other cases. Keela, we've talked, privately, that this thing comes up all the time. Interestingly, though, there's not really clear case law in Florida that would say, one way, yes or no, you're entitled to college records, or you're entitled to cell phone records, or et cetera. Obviously, things are on a case-by-case basis, but I feel like there's a growing trend where the expectation is you got to give it all up.
Yeah, I mean, I think there is. And the problem is it shouldn't be, because some things are relevant and some things are not. And yes, being a plaintiff in a personal injury lawsuit, your whole life is on examination, right? You're being followed, you're being judged, you're being poked and prodded, you're going to defense medical exam, you're being questioned, you're being called a liar. And it's like somebody did something to me, right? You smashed into me. Your flooring was dangerous, and I'm the one that's the bad guy. And I think it's disgusting. I get offended. I get personally offended. And I forget, it was in some kind of book, and it might have been in like Raleigh's book, where it was like a letter from a client of like what they went through, like a traumatic brain injury client, and what they went through, and it kind of opened my eyes to like what the plaintiffs have to do, the courage they really have to even get to trial. Like, they have to have so much. And then when you're exposing your life, we object. I mean, they want like female wellness issues in a case where, and they're like, well, they might be complaining about back pain. And it's like, no, it has, and so we object. And what the law, and I think that what the law says is, because in Florida, we do have a constitutional right to privacy. That is in our Constitution. The court has to do two things. One, it has to perform a balancing test, and it has to do an in-camera review. It has to. It's mandatory, right? So, and a lot of the trial court judges are overworked. And when you say, look, judge, I'm going to object, but you can get the records. It has to come to you, and you have to do a full, complete in-camera inspection of all 400 pages of these records and determine if there's something relevant. They don't want to do that. So what happens a lot of times, they say, look, we'll send it to you as the plaintiff's lawyer. You look through it. If there's anything that's relevant, you turn it over. If not, then you say there's nothing in there, right? And that's what we've seen happen.
The upshot of that, obviously, is your client's rights are being protected, right?
Correct.
You can't guarantee that nothing will get disclosed, but you can guarantee your client that degree of protection, that some independent intermediary is going to review them, or that we will first and really make sure that there's nothing in there that is revealing too much.